Afternoon, sir. Could I have your name, please?
Jonathan James Winter.
All right, Mr. Winter, my name is Judge Hesslink. I'll be arraigning you this afternoon. That involves me reading the charges to you, then telling you what your rights are, and then addressing bond. I have with me on Zoom Mr. Brown as a defense attorney and Mr. Fortier from the prosecutor's office. The charge in the complaint against you reads as follows. It says, in honor about July the 10th of 2025 in Bagley Township of Otsego County, that you did commit the following two offenses. Count one is entitled breaking and entering a vehicle to steal property between $200 and $1,000. It says that you did enter or break into a Chevy Equinox, a motor vehicle, to steal or unlawfully remove property therefrom of a value of $200 or more, but less than $1,000, contrary to Michigan compiled law. That is a misdemeanor offense. It has a maximum penalty of 1 year and or $2,000 fine, or 3 times the value of the property stolen, whichever is greater. Do you understand the name of count one?
It's a misdemeanor count, correct?
That's correct. Do you understand the name of it to be breaking and entering a vehicle to steal property between $200 and $1,000?
Okay.
I just need to know if you understand that, sir. Not asking if you agree with it.
Yes, I understand.
All right. And you understand the misdemeanor maximum penalty is 1 year and or $2,000 and up to 3 times the value of the property, whichever is greater?
Yep.
All right. Count two reads as follows. It says that on the same date, time, and place that you did commit the offense of breaking and entering a vehicle to steal property less than $200. And that says that you did enter or break into a Ford F-150, a motor vehicle, to steal property or unlawfully remove property therefrom of a value less than $200. That also is a misdemeanor offense, but it has a maximum penalty of 93 days and or $500, or 3 times the value of the property stolen, whichever is greater. You understand the name of count two?
Yes.
You understand the maximum penalty for count two?
Yes, unfortunately, that's exactly how bad it looks right now. You can see how quickly a small problem has escalated. This guy is making the worst decisions possible at every turn. Turning a misdemeanor into a potential long-term prison sentence is shocking. And yes, it's all because of his own actions and choices. He's stacking mistake on top of mistake, like it's some kind of talent. This isn't luck. It's pure chaos in motion, and the judge is already showing zero patience for it. Every move he makes just digs the hole even deeper. The audience should understand how quickly things can spiral completely out of control.
Yes.
All right. Right now, you have certain rights as to those charges, and I want to make sure that you understand them so that you can make an informed decision in the future. You have the right to plead guilty, not guilty, or no contest. You have the right to an attorney to represent you, and you have the right to have a trial by a judge or by a jury. Mr. Brown is here to assist us with the attorney, and we'll talk about that in just a minute. If you wish to have a trial in the future, you also have the following trial rights: to see, hear, and question all the witnesses against you, to present witnesses and evidence for your defense, and to get an order from the court called a subpoena to require those witnesses to appear and testify. At trial, you could also testify, or you could choose to remain silent. And if you chose to remain silent, that silence could not be used against you. You'd also have the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof be on the prosecutor at all times. Finally, you'd also have the right to appeal automatically any error that happened at trial. However, if you enter a plea in the future, you may be limited to asking the court for permission to appeal. Do you understand all of those trial rights?
Yes.
Do you have any questions about any of those trial rights?
No.
All right. Mr. Brown, have you had a chance to speak to Mr. Winter about his right to an attorney?
Yes, Your Honor. He would qualify, and that information has been sent to Mr. Keel's office.
Thank you. Mr. Winter, are you asking for court-appointed counsel?
Yes.
All right. I will approve that request. That request has been submitted to that approval will be submitted to Mr. Gilo, who's the supervisor of the court-appointed attorneys. He will decide which specific attorney will be assigned to you for your case. In the meantime, I'm going to enter a not guilty plea on your behalf in order to protect your rights until you have a chance to speak with that lawyer. I'm also going to set a pretrial conference quickly so that your lawyer can speak with the prosecutor and see if they can resolve the case quickly as well. You have any questions about those procedures, sir?
No, I just need to be able to talk to my attorney because there is extenuating circumstances.
Well, we'll get into that later. You don't want to talk about anything right now, Mr. Warner.
Yep, and that's why I've set a quick
Yeah, like I said, I
pretrial
want to talk to my
conference.
attorney as soon as possible.
It's almost unbelievable how efficiently he manages to make things worse. You can watch a 1-year misdemeanor potentially become something far bigger. Michigan doesn't mess around. And this is a perfect example. Every bad choice now has serious consequences that he can't avoid. Even small criminal mistakes can cascade into long-term penalties. He's not incompetent. He's just extremely unlucky and reckless. At the same time, courtroom rules exist for a reason. And he's testing every single one. This isn't some exaggeration. It's the real risk he faces. The judge is clearly not impressed by his criminal creativity. Viewers should be shaking their heads at this level of self-sabotage.
Yep, that's what we're going to do. So I'll get the paperwork and get it to Mr. Gilo's office, and he'll get that information to you, and then the attorney will contact you subsequently. All right, now that we've set those things, I will address bond. So what I'm going to do is I'm going to hear from each of the attorneys as to bond, and then, sir, I'm going to listen to what you have to say, if anything, about bond as well. So, Mr. Fortier, your thoughts.
Your Honor, I did submit a bond recommendation form. In there, I did request a $5,000 cash or surety bond. That's largely, I mean, it's a larger amount considering what he's charged with in the fact that they're both misdemeanors. However, I'm requesting that amount partially based on the fact that these were two thefts within motor vehicles that were part of a string of essentially vehicle burglaries. And on top of that, his criminal history is quite extensive. It is listed in that recommendation form. He's out on parole for a home invasion second degree. So he's got a history of stealing other people's property. That wasn't even his first home invasion. He had another one back in 2008. So like I said, he's on parole for that. He does have a parole hold. I confirmed that with Agent Doug DeLeo with the Department of Corrections. So there is an administrative warrant that's holding him. So regardless of what the court sets the bond amount at, he's not going anywhere, essentially. So in addition to the amount requested, we are seeking that there be the standard conditions of bond, along with no drugs or alcohol, no illicit controlled substances, and then to not have any contact with Timony Bonifant or Mallory Bonifant. They are the two vehicle owners that are in this case, and then also not to return to the property of 19 Grove Avenue here in Gaylord. That's the property where the theft occurred.
All right, Mr. Brown.
Thank you, Your Honor. Mr. Winter is a lifelong resident of this county. He has ties to this community. I don't think he's going to go anywhere. Failure to appear is not really going to be an issue. It is my understanding he did, or possibly was arraigned yesterday on an FOC warrant. So I don't know if there's a significant bond in that matter as well. But as Mr. Fortier mentioned, he is on a parole hold, so bond is really not a huge issue, as he's not going to be able to bond out no matter what it is set at. But I would ask the court just to consider the charges. These are misdemeanor charges. Also, he did mention to me that he does have some mental health issues that he is taking medication for. I don't know what the jail's policy is or if he's getting those medications, but that is something that he requested that he be provided any kind of medications that he needs. And then, again, I don't know who even has those medications. Thank you.
Those medications are here at the jail now, Your Honor.
Thank you for letting me know that. I appreciate it. Mr. Winter, you also have the right to speak to me about bond. However, I simply want to caution you not to make any statements about the underlying facts of this case because we are recording this proceeding and I don't want it to be used against you in the future. Is there anything else, however, that you want me to be aware of in setting a bond?
No, Your Honor, I have to speak to my attorney about that.
Now don't get it twisted. He's probably not facing life in prison, but the way Michigan handles repeat offenses is no joke. This is a reminder that courts take prior history very seriously. He's essentially playing a high-stakes game with very real rules. The judge isn't going to cut corners just because he's desperate, and watching this unfold is a perfect lesson in consequences. Every bad decision he makes now is magnified tenfold. The courtroom doesn't care about excuses. Only actions and history. He's learning the hard way that law enforcement remembers everything. The audience needs to grasp that this is not a game.
All right. I will let you do that. And if he wishes in the future, he can readdress that issue and I'll consider it at that point. I would confirm because Mr. Brown brought it up, there was a friend of the court hearing, I believe either yesterday or the day before. My memory is that there was a bond set in the amount of $4,900 that he could be released upon payment of that. I do not know whether that has occurred yet or not. So
I have not been able to do that, Your Honor. I'm not going to be able to do that.
All right. I appreciate that, Mr. Winter. Thank you. All right. In setting a bond, I am required to look at whether or not the person will appear as required, and then if there's any danger to the community. The prosecutor brings up history, and which is quite extensive, including resisting and obstructing convictions twice in 2004, larceny in a building in 2004, home invasion in third in 2008, prisoner in possession of weapons in 2013, and then a second home invasion, this time a home invasion second in 2019. Also, what the prosecutor alleges is a string of vehicle burglaries, of which this may have been a part. So for those reasons, I would need to believe that Mr. Winter might be a danger to the community. However, these are simply misdemeanor matters, and I do believe that $5,000 cash and surety is a little high on that end, given the fact that he has a parole hold and also an FOC warrant with extensive, relatively large dollar amount on it. It's unlikely he's going to be able to post bond, so therefore I'm not going to set the bond in this matter quite so high. I will set it at, because of his prior histories, I'm not going to give him a 10% bond, so I will set it simply at $500 cash or surety.
Again, he's hearing the maximum penalties, and it's not sugar-coated. This is what happens when you ignore legal advice. Repeatedly understanding charges isn't optional. It's critical for survival. In court, the judge is making sure there's no confusion about the consequences. Even a small misstep now could have huge ripple effects. Later, the lawyer is clearly overwhelmed by the sudden chaos of the case, and the defendant's reactions show he's not fully processing any of it. This is a masterclass in how not to handle court proceedings. Everyone watching can see just how quickly things are spiraling. It's a warning to anyone thinking they can skate by with bad choices.
All right. Good afternoon, everyone. Welcome back to the district court. The call the matter is the state of Michigan versus Alex Dopfer.
Your Honor, I believe that's Mr. Winter.
Is that Mr. Winter? All right. We'll change things here. All right, this is the state of Michigan versus Jonathan Winter, file 25-43924-FY. Can I have your name for the record, sir?
Jonathan James Winter.
All right, Mr. Winter, my name is Judge Hesselink. I'm coming to you from the district court. You're here today for an arraignment, so I'm going to tell you what you're charged with, tell you what your rights are, and then we'll discuss bond. The complaint that's been made against you reads as follows. It says that on or about July the 7th of 2025 in the city of Gaylord, Otsego County, that you did commit the following two offenses. Count one is named breaking and entering a building with intent. It reads that you did break and enter a storage shed located at 619 West Mitchell Street with the intent to commit the crime of larceny therein, contrary to the Michigan compiled laws. That is a felony offense and has a maximum penalty of 10 years. you understand the name of that offense?
No.
What don't you understand about it?
What's the date of that offense?
The name of that offense.
Oh, I'm sorry, Your Honor. Yes, I understand.
All right. Do you understand the maximum penalty of that offense?
Yeah.
All right. Count 2 alleges stolen property, receiving and concealing over $200 but less than $1,000. It reads as follows. It says that on that same date, time, and place, July 7th of 2025, in the city of Gaylord, Otsego County, that you did commit the offense of receiving and concealing stolen property over $200 but less than $1,000 by buying, receiving, possessing, concealing, or aiding in the concealing of an e-bike, stolen, embezzled, or converted property, knowing that it was, or having reason to know that it was the property was stolen, embezzled, or converted, and the value was between $200 and $1,000. That is a misdemeanor offense. It has a maximum penalty of 1 year and or $2,000 or 3 times the value of the property, whichever is greater. Do you understand the name of count 2?
Yes.
You understand the maximum possible penalty of count 2?
Yes.
All right.
Calm down. This isn't the time for panic or theatrics. His court-appointed lawyer literally just got pulled into the chaos. He has no real defense ready. And it's showing in the courtroom. Judges notice hesitation and disorganization. And that's exactly what's happening. This little guy is clearly out of his depth. Completely every second counts. And now he's got to rely on a stranger. It's almost painful to watch him flail under pressure. The audience should recognize how fast panic can compound problems. Lawyers aren't magic. They need time and cooperation to work. This scene shows exactly why preparation matters more than luck in court.